Can you hear me?
Yes, ma'am.
Oh, okay, good. Good morning, Mr. Austin.
Good morning, Judge. Or afternoon, as the case may be.
I knew that the email from Mr. Silverthorne was an error, but I wasn't going to tell him. I was like, I'm pretty sure Mr. Austin told me he was doing today. But maybe you all switched. I didn't know. Okay, let's see. Okay, on the record in the matter of the people of the state of Michigan versus Johnny Martel Hinton, counsel appearance.
Thank you, Your Honor, and good afternoon. Jared Austin appearing today on behalf of Mr. Hinton for the purpose of this appearance only.
Okay, are you Mr. Johnny Hinton?
Yes, ma'am.
Okay, Mr. Hinton, I have a felony warrant and complaint here that I'm going to arraign you on. It states here that on or about February 17, 2024 through February 19, 2024 at the area of 1222 Big Street, City of Lansing, Ingham County, State of Michigan, that you did allegedly, contrary to the law, commit the act in count 1 with assault with intent to do great bodily harm less than murder or by strangulation. The allegations are that you did make an assault upon a Cynthia Solis by strangulation or suffocation, contrary to Michigan Compiled Law 750.84. Count 1 is a felony with a maximum penalty of 10 years in prison or $5,000 in fines. Your DNA is to be taken upon arrest, and a consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. There is a count 2 of interfering with electronic communications. The allegations is that you did willfully and maliciously prevent, obstruct, delay by any means the sending, conveyance, or delivery of an authorized communication by or through a telephone or telephone line. That's contrary to Michigan Compiled Law 750.5405A. Count 2 is a felony with a maximum penalty of 2 years in prison and or $1,000 in fines. Count 3 is domestic violence, and it alleges that you did make an assault or an assault and battery. Let me rephrase that. Count 3 and count 4 are domestic violence charges. Both count 3 and 4 alleges that you did make an assault or assault and battery upon Cynthia Solis in both counts, an individual with whom you had a dating relationship, and this is contrary to Michigan Compiled Law 750.812. Count 3 and count 4 are misdemeanors. Maximum penalty is 93 days in jail and or $500 in fines, and a consecutive sentence may be imposed under the law if the assaults were committed in a place of confinement. Do you understand the charges read in counts 1 through 4 and the maximum penalty attached to each count? I'm sorry, there was a delay. I did not hear your response, sir.
Yes, ma'am.
Okay, you have the right to be represented by counsel, and you're represented by Mr. Austin from the Office of the Public Defender for the purposes solely of your arraignment. You do have the right to have an attorney represent you at each stage of the criminal prosecution. They are to represent you at all your court appearances, and you have the right to have an attorney represent you if you're questioned by law enforcement. If you cannot afford to hire your own attorney, you can make a request to have the public defender's office appointed at the expense of the public. Do you understand your right to counsel?
Yes, ma'am.
Okay, and he's requested court-appointed counsel, Mr. Austin?
He has, Your Honor.
Okay. Okay, Mr. Hinton, you have the right to remain silent. Anything you say and anything you put in writing can be used against you. You have the right to plead guilty. You can plead not guilty or you can stand mute. If you stand mute, this matter will proceed all the way to jury trial. For the purposes of your arraignment, the court is going to enter a plea of not guilty on your behalf. You have the right in this matter because you are being charged in count 1 and count 2 with felonies to proceed to a preliminary examination. You have the right to have preliminary examination within 21 days of the date that you're arraigned. So that's 21 days from today's date. At the time of your examination, you have the right to require the prosecution to put forth evidence to establish that they have sufficient probable cause that a crime was committed and then probable cause sufficient to charge you with the crime. You understand your right to examination?
Yes, ma'am.
Okay, and your preliminary examination timeline can be waived by the court if they find good cause to go beyond the 21 days, or you can waive it yourself. Other than that, your probable cause conference is currently scheduled for February 29th, 2024 before Judge Stacia Buchanan at 9:30 in the morning. You have a preliminary examination before Buchanan in person at the court, March 7th, 2024 at 8:30 in the morning. So again, you can appear to your probable cause conference via Zoom or in person. That's up to you. If you're going to appear via Zoom, you just need to make sure you have the capabilities of video to appear, okay?
Yes, ma'am.
Okay, did you get your notice to appear and the Zoom instructions for Judge Buchanan's courtroom?
Yes, ma'am.
Again, you have the right to remain silent. So anything you say, anything that you put in writing can be used against you. You have the right to proceed to a trial. And you have the right to a jury trial in this matter. At the time of trial, you enjoy the presumption of innocence. So you're innocent until proven guilty. You have the right to require the prosecution prove your guilt at your jury trial by proving each element of the charges being brought against you beyond a reasonable doubt. You have the right to see, hear, or question in court at the time of your trial any of the witnesses that the prosecution intends to call against you. You have the right to have witnesses subpoenaed to testify on your behalf at trial. And you also have the right to put forth evidence that you believe show a defense of the charges being brought against you at your trial. You also have the right to remain silent at trial and not have silence be used against you. Do you have any questions about your trial rights?
No, ma'am.
Are you currently employed?
Yes, ma'am.
Where's that?
I cut hair.
What's your home address?
1222 Bench Street.
Is that the address of Miss Cynthia Solis?
Yes, ma'am.
Okay, well, you're not gonna be able to reside there during the pendency of this matter if that's where she resides. So where can you
Yeah.
stay?
My sister's ma'am.
What's that address?
I have to ask my sister. I don't know.
Is that in Lansing?
It's in Hope.
What's your phone number?
757-203-3351.
3351
Yes, ma'am.
757 from Virginia.
Oh.
Counsel, you can address bond.
Yes, thank you, Your Honor. As Mr. Hinton stated, he is residing in our community. As he states, he's also gainfully employed. I don't know the extent of what prior criminal history Mr. Hinton has, other than I did do a Michigan eye chat, and the only thing that I saw on that was a couple misdemeanor drunk driving offenses from approximately 15 years ago. I understand that these allegations are assaultive in nature. The presumption is that Mr. Hinton did not commit them. As he stated, he has family in the area. He will be residing with family in order to abide by the no contact order. I have no information that he has a history of failing to appear in court, so that I believe, given that, he will do so. I would ask the court to consider releasing him on his own recognizance. If the court does not feel that is appropriate, then I would ask for a reasonable 10% bond in the alternative. Thank you.
Thank you. Mr. Hinton, how long have you been in Michigan?
Maybe 4 weeks.
You were in Virginia prior to that?
Yes, ma'am.
Bond is set in the amount of 5,000, 10% with GPS tether. While out on bond, you have the following conditions. First, you're not to engage in any assaultive or threatening behavior. You're not to have contact directly or indirectly with Cynthia Solis. Do you understand that?
Yes, ma'am.
You're not to cause anyone to have third-party contact or communication with Cynthia Solis. Do you have questions about what that might mean?
No, ma'am.
I would imagine that you have personal items probably at the address at 122 Bank Street. I will allow you to go accompanied by law enforcement to get your items one time, okay? While out on bond, you're not to use, purchase, or possess alcohol, marijuana, or a controlled substance unless you have a valid prescription. You're not to travel outside the state unless you get approval for the court first. Do you understand that?
Yes, ma'am.
You're not to possess a firearm or any other dangerous weapon. And you need to report to pretrial services within 48 hours of your release. You can get contact information or the information on how you make contact with pretrial services from the jail. Do you have any questions about your bond conditions?
No, ma'am.
You also need to make sure you appear to all of your court dates, and you've received your court dates for the next 2 court dates already. Do you have any questions at this time about your court dates?
No, ma'am.
Okay, any additional matters for the record, counsel?
Nothing additional, Your Honor. Thank you.
Thank you. You're all set, sir. On the record in the matter of the people of the state of Michigan versus Blake Johnson. Council appearance.
Good afternoon, Your Honor. Jared Austin appearing today on behalf of Blake Johnson. My appearance is limited to this hearing only.
You're Blake Johnson?
Yes.
Okay. Today's the date and the time that's set for arraignment. Let's see. I have a felony complaint that alleges that on or about February 18, 2024 at 1632 Robertson Avenue, City of Lansing, Ingham County, State of Michigan. That you did allegedly, contrary to law, commit the act in count 1 of assault with intent to do great bodily harm, less than murder, or by strangulation. The allegations are that you did make an assault upon a Sinoja Ross with the intent to do great bodily harm, less than murder, or by strangulation or suffocation, contrary to MCL 750.84. That's a felony. The maximum penalty is 10 years in prison and or $5,000 in fines. Your DNA is to be taken upon arrest, and a consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. There is a count 2 of domestic violence that alleges that you did make an assault or assault and battery upon a Sinoja Ross, a resident or former resident of your household, or an individual with whom you had a dating relationship, that this is contrary to Michigan compiled law 750.812. Count 2 is a misdemeanor, maximum penalty 93 days in jail and or $500 in fines. A consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. Do you understand the charges in counts 1 and count 2 and the maximum penalty?
Yes, ma'am.
Okay, you have the right to be represented by counsel. Mr. Austin is representing you today for the purposes of your arraignment only. You do have the right to have an attorney represent you at all of your court appearances, and you have the right to have an attorney represent you if you're questioned by law enforcement. If you cannot afford to hire your own attorney, you can make a request to have the public defender's office represent you at the expense of the public. You understand your right to counsel?
Yes, ma'am.
Thank you. Is there a request for public defense representation, Mr. Austin?
Yes, Your Honor.
And the court will also enter a plea of not guilty on your behalf. But I will advise you that you do have the right to plead guilty. You have the right to plead not guilty, and you have the right to stand mute. If you stood mute, this matter will proceed all the way through to a trial, and you have the right to jury trial. But prior to your trial, you need to be advised that you do have the right to a preliminary examination because count 1 is a felony. So you have the right to have your preliminary examination within 21 days of the date that you're arraigned. That's 21 days from today's date, unless you waive that timeline of 21 days or the court finds good cause to go beyond the 21 days for some reason. During your preliminary examination, you have the right to require the prosecution put forth evidence to establish whether or not they have sufficient probable cause that a crime was committed, and then probable cause sufficient to charge you with the crimes alleged, okay?
Yes, ma'am.
You're currently scheduled for probable cause conference before Judge Cynthia Ward, March 1st, 2024, 8 a.m. And you can appear via Zoom if you have a video, or you can come in person for the probable cause conference. You have a preliminary examination before Judge Ward, March 7th, 2024 at 9 o'clock in the morning. You got your notice to appear and your Zoom instructions for Judge Ward. That was a question for you.
Yes, ma'am.
Okay, so you have to appear in person again for the preliminary examination. You have the right to the presumption of innocence, so you're innocent until proven guilty. You have the right to proceed to a jury trial. You have the right at the time of your jury trial to remain silent and not have silence be used against you. You have the right to confront your accusers in court and cross-examine any witnesses in court that the prosecutor calls against you. You have the right to call your own witnesses to trial to testify on your behalf, and you have the right to present evidence at trial that you believe show a defense to the charge being brought against you. You have the right to require the prosecutor prove your guilt at trial by proving each element beyond a reasonable doubt of the charges being brought against you. Do you have any questions about those rights?
No, ma'am.
Are you currently on probation or on parole?
No,
Do you have any other matters pending with the court?
no,
Are you employed?
yes.
Where is that?
Dave's Hot Chicken.
What's your home address?
1632 Robertson.
Is that the address of Sonoja Ross?
Yes, ma'am.
Okay, well, you're not gonna be able to live there if that's where Sonoja Ross is living. So where are you gonna stay?
3145 North Grand.
3145 North Grand River, you said?
Yes, ma'am.
Whose house is that?
My father's.
What's your phone number?
517-410-0639.
I don't have a criminal history for. Blake Johnson. Do we get a criminal history for Blake Johnson? I don't see the fingerprints or a criminal history in this file.
Your Honor, I did an iChat and I did not see any convictions on the iChat. There appeared to be an embezzlement charge from 2018, but I did not see any disposition on that.
Okay. Okay, you can adjust bond.
Thank you, Your Honor. As I stated, I did not see that there was any public convictions, at least as an adult here. So I think that is a positive factor. There appears to be ties to the community, given the alternative address that was provided. We'll be living with family in order to abide by the no contact order. There's also gainful employment here. So all of those lead me to believe that personal recognizance release would be appropriate. and proper bond conditions can address any safety concerns to either the complaining witness or to the community. And that is what I would ask the court to impose. It does sound like there are some personal effects that would need to be gathered from the Robertson Avenue address. So I would ask if the court would permit a one-time trip back to the residence accompanied with law enforcement to gain those personal effects. Thank you.
Bond is set at 500 personal recognizance. While out on bond, you have the following conditions. You not to have contact directly or indirectly that includes any third-party communication or attempts to make communication with a Synosia Ross. Do you understand that?
Yes, ma'am.
Okay, you're not to be at the address of 1632 Robertson Avenue, so long as that's the address of Synosia Ross. You are allowed to go once accompanied by law enforcement to remove your personal items. You're not to be within 1,500 feet of wherever Synosia Ross is. Do you have any questions about that?
No, ma'am.
You're not to engage in any assaultive or threatening behavior. You're not to use, purchase, or possess alcohol or drugs unless you have a valid prescription. You're not to travel outside the state without prior approval of the court. You're not to possess a firearm or any other dangerous weapon, and you must report to pretrial services within 48 hours of your release, okay?
Yes, ma'am.
Do you have any questions about your bond conditions?
No.
Any additional matters for the record, counsel?
Nothing additional, Your Honor. Thank you.
You're all set. Thank you. On the record in the matter of the people of the state of Michigan versus Ashley Marie Mays, counsel appearance.
Good afternoon, Your Honor. Jared Austin appearing today on behalf of Miss Mays. My appearance is limited to this hearing only.
Step forward, please. Okay, and you're Ashley Marie Mays?
Yeah.
Okay, Ms. Mays, I have a misdemeanor complaint here that you're going to be arraigned on. It states that on or about February 18, 2024, at the area of 2220 Newark Ave, City of Lansing, Ingham County, State of Michigan, that you did allegedly contrary to law commit the act in count 1, an assault or assault and battery upon a Kimberly Burnett, and in count 2, assault or assault and battery upon a Michael Burnett. The allegations in both count 1 and count 2 allege that you did make an assault or assault and battery upon those persons contrary to in Michigan compiled law 750.811. Both count 1 and count 2 are misdemeanors with the maximum penalty 93 days in jail and or $500 in fines, and a consecutive sentence may be imposed under MCL 750.506A if the assault was committed in a place of confinement. Count 3, malicious destruction of personal property less than 200. It alleges that you did willfully and maliciously destroy or injure a book, car, the personal property of Ashley Pratt, and the amount of the destruction or injury was less than 200. I'm assuming the way this is written is that it's both a book and a car, but it says injure a book, car, the personal property of Ashley Pratt. And again, the amount of the destruction was less than $200, contrary to Michigan compiled law 750.377A1E. Count 3 is a misdemeanor, and the maximum penalty is 93 days in jail and or $500 in fines, or 3 times the amount of the destruction or injury, whichever is greater. Do you understand the charges in counts 1 through 3 and the maximum penalty? That question was for you, Ms. Mays.
Yes, ma'am.
Okay, you have the right to be represented by counsel, and you are represented today by Mr. Austin from the Office of the Public Defender, but he's only representing you for the purposes of your arraignment. You do have the right to have counsel represent you and advise you throughout the pendency of the criminal prosecution and to appear with you at each court appearance. You have the right to have an attorney represent you if you're questioned by law enforcement. Do you understand those rights?
Yes, ma'am.
Is she requesting a public defender?
She is, Your Honor.
Ms. Mays, you have the right to remain silent. Anything that you say and anything you put in writing can be used against you. You have the right to plead guilty. You can plead not guilty, or you can stand mute, but if you stand mute, the matter will proceed all the way to a jury trial. The court will enter a plea of not guilty on your behalf at this time. You have the right in this matter to proceed to jury trial, and at the time of your trial, you enjoy the presumption of innocence. So that means you're innocent until proven guilty. You have the right to require the prosecution prove your guilt at your trial by proving each element of the charge being brought against you beyond a reasonable doubt. You have the right to remain silent at trial and not have silence be used against you. You have the right to call witnesses to speak for you at your trial, or to present evidence at your trial that you believe show a defense to the charge being brought against you, or the charges being brought against you. You have the right to see, hear, and question any of the witnesses that the prosecution brings against you at trial. And again, you have the right to require the prosecution prove your guilt by proving each element of each of the charges beyond a reasonable doubt. Do you have any questions about those rights?
No, ma'am.
Are you currently employed?
Yes, ma'am.
Where is that?
I'm self-employed. I am a housekeeper, about 7 years now.
What's your home address?
1442 Robertson Avenue in Lansing.
What's your phone number?
517-619-2439.
Okay, your next court date is going to be a pretrial. You'll receive a copy of that notice in the mail. If you don't get a copy of the notice within the next week, it's your responsibility to contact the court to find out why you didn't receive notice of your next court date, okay?
Okay.
That way you won't miss a court date, because if you miss your next court date, which will be a concern, you will get a bench warrant issued, and you don't want that, okay?
Yes, ma'am.
Are you currently on probation or on parole?
Ma'am.
Do you have any other court matters pending?
No.
Address bond, counsel.
Thank you, Your Honor. As Ms. Mays stated, she is gainfully employed. She lives here locally with her two children. My understanding is she has lived in the county for nearly 10 years, for Lansing for the last couple years. I did not see any prior criminal convictions when I did an iChat on Miss Mays. Doesn't sound like that there's going to be any issues with her abiding by the no contact order in this case. Given that, Your Honor, I think personal recognizance release would be appropriate, and that is what I would ask the court to impose. Thank you.
Okay, I'm reviewing her prior criminal history. I don't see any prior criminal history, or I should say, let me rephrase that. I don't see any prior criminal convictions, but in the last 5 years, I see 5 domestic violence charges, which should be noted on the record as a concern, but there's been no convictions. In this particular matter, I don't think that there's a threat to the public safety. I do believe that personal recognizance is sufficient at this time. I will grant the request. Bond will be set at 500 personal recognizance with the following conditions. You're not to have any contact directly, indirectly, or through any third-party mechanism with the alleged victims in this matter, and that being Kimberly Burnett and Michael Burnett. Do you understand that?
Yes, ma'am.
You're not to be within 1,500 feet of wherever they live. Do you understand that?
Yes, ma'am.
You're also not to be within 1,500 feet of wherever they work or do any other of their business. Do you understand that?
Yes, ma'am.
You're not to engage in any assaultive or threatening behavior. You cannot leave the state without prior approval of the court. You're not to possess a firearm or any other dangerous weapon, and you're not to use any drugs or alcohol unless you got a prescription. Do you understand that?
Yeah.
Excuse me?
Yes, ma'am.
Have any questions?
No, ma'am.
Any additional matters for the record, counsel?
Nothing additional, Your Honor. Thank you.
You're all set, ma'am.
Thank you.
You're welcome. On the record, in the matter of the people of the state of Michigan versus Christasia Castillia. Counsel appearance.
Morning, Your Honor. Jared Austin appearing on behalf of Christasia Christalia for the purpose of this hearing only.
And you're Christasia Castillia?
Yeah, that's correct.
Okay, today's the date that we're proceeding with an arraignment. I do have a misdemeanor complaint. It alleges that on or about February 19, 2024, at the area of 1215 East Michigan Ave, City of Lansing, Ingham County, State of Michigan, that you did allegedly in count 1 commit the act of disorderly person obscene conduct. The allegation is that you, being a disorderly person, to wit, a person who engaged in indecent or obscene conduct in a public place, that being the Sparrow Hospital, and that this was contrary to Michigan Compiled Law 750.1671F. Count 1 is a misdemeanor, and the maximum penalty is 90 days in jail and or $500 in fines. And the court shall order law enforcement to collect DNA identification profiling samples. Count 2 is trespass. The allegation is that you did enter the lands or premises of Sparrow Hospital without lawful authority after having been forbidden to do so by Officer Faust, who was an agent or of the owner of the lands or premises, and that this was contrary to Michigan Compile Law 750.552. Count 2 is a misdemeanor with a maximum penalty of 30 days in jail and or $250 in fines. Do you understand the charges that was just read and the maximum penalty attached to each charge? You have the right to be represented by an attorney. Mr. Austin is representing you today only for your arraignment. You do have the right to have an attorney represent you at each stage of the criminal prosecution, and you have the right to have an attorney appear with you at all of your court appearances and if you are questioned by law enforcement. Do you understand that right?
Yes.
You have the right to remain silent. Anything that you say can and will be used against you. You have the right to plead guilty, plead not guilty, or stand mute. If you stand mute, this matter will proceed to a trial. You have the right to a jury trial, and you have the right to the presumption of innocence. So you're innocent until proven guilty. You have the right to require the prosecutor to prove your guilt at your jury trial by proving each element of the charges being brought against you beyond a reasonable doubt. You have the right to see, hear, or question any witness they call during your trial in court. You have the right to have witnesses subpoenaed to testify on your own behalf, and you have the right to present evidence at your trial that you believe show a defense to the charge being brought against you. And you have the right to require the prosecutor to prove each element of counts 1 and counts 2 at your trial by proving each element beyond a reasonable doubt. Again, back to your right to representation. Mr. Austin, is she requesting court-appointed counsel?
Well, Your Honor, I will say that I have not had occasion to speak with her today. She was not on the list I was provided. I was not told that I needed to speak with her. So I would defer to her on that, but I would err on the side of requesting court-appointed counsel on her behalf.
Okay, Ms. Castillia, did you want an attorney to represent you? If you cannot afford to hire your own attorney, an attorney can be appointed at the expense of the public. So is that something you'd like?
Yes.
Okay, I'll note that here, and then Mr. Austin will make sure she meets with you today so you can complete the intake.
I would appreciate that. Thank you.
Thank you. The court will also enter a plea of not guilty on her behalf today. She will get notice of her next court date, which will be a pre-trial, and which judge she's assigned to in the mail. What's your home address, Ms. Castillia?
1309 Vermont Avenue.
Can you repeat that for me?
1309 Vermont Avenue.
Okay. Is there an apartment at all?
No, it's a house.
Okay. Are you employed?
No.
What's your phone number?
Area code 207-619-2842.
Okay, the court's gonna go ahead and set your bond at $500 personal recognizance. While out on bond, you're not to engage in any assaultive or threatening behavior. You're not to travel outside the state without prior approval of the court. You need to report to all of your future court dates. Again, your next court date is going to be mailed to the address at 1309 Vermont Ave. If you do not receive that within the next week, you reach out to the court to find out what your next court date is, okay?
Yeah.
You also are not to use, purchase, or possess drugs or alcohol without a valid prescription, and you're not to possess a firearm or any other dangerous weapon. Do you have any questions today about your bond conditions?
No.
Okay, well, you're all set for today, but you do need to meet with the public defender before you leave, okay?
Okay.
Lastly, I'm also gonna place an order that you're not to be at the address of 1215 East Michigan Avenue, which is the Sparrow Hospital, unless you're being admitted for medical purposes. Do you understand that? Ma'am, I just asked you a question.
I said yes.
Okay, thank you.
And Ms. O'Leary, here.
This is the people of the state of Michigan versus John Yang, file number 23-02412. Appearance for the record.
Good afternoon, Your Honor. Jared Austin appearing today on behalf of Mr. Yang. My appearance is for the purpose of this hearing only.
Can you step forward, please? You're Mr. John Yang?
Yes, ma'am.
Okay, I have a police report here and a complaint for violation of bond condition, also known as a PA 53 violation. And so the allegations are that you are currently out on bond before the 54A District Court, and one of those conditions is for you not to commit any crime while released. Upon review of the police report that I have here from February 18, 2024, at approximately 11:03 p.m., the allegation is that you did commit the act of furnishing false information to a police officer. And so I'm not sure if that's a issue or an action that you'll sustain additional charges from the city. But if that is the case, that would be a violation of your bond condition under Section D, which is not to commit any crime while released. You do have the right to have a contested hearing as to any bond conditions, because if you are found to be in violation of your bond can be terminated and you can be sentenced or remanded to the jail pending your underlying criminal action before the court. You also could have sanctions for violating the court order for your bond, and those sanctions are punishable with a maximum penalty of 93 days in jail and or $7,500 in fines. Do you understand those rights?
Ma'am.
Okay, my understanding is that you already have a court-appointed attorney on the underlying cases. Is that accurate, Mr. Austin?
My understanding as well.
Okay, the court will enter a plea of not guilty for the PA 53, and it'll be set for a hearing. And you'll get a notice of that in the mail, and your attorney will be advised. What's your address, sir?
3015 Newark Ave, Lansing, Michigan, 4911.
Okay, I'm gonna issue a bond of $500 on the PA 53, and he's all set. All your other bond conditions from your underlying matters will continue, okay, sir?
Man,
Thank you.
And Your Honor,
Yes.
just so I can make an accurate
have another
record,
matter?
what is the file number on that PA 50?
Actually, Mr. Yang, I think has another matter. He needs to come back. I have his other matter.
That's, I thought that as well.
Okay, Mr. Yang, my apologies. You did have another file here. Let's see. Okay, people of the state of Michigan versus John Yang, file number 23-02412 FY, council appearance.
Good afternoon, Your Honor. Jared Austin appearing on behalf of Mr. Yang for the purpose of this arraignment only.
Okay, Mr. Yang. I think this is the other file that the bond conditions were issued on, and this file is assigned to my courtroom. But you were not immediately familiar to me. Do you know why?
no, man.
Because you were supposed to appear before me back on the 28th of December and you never showed. And then you were supposed to appear before me on January 14th and you never showed. So this is my first time seeing you, and I issued a bench warrant.
I was arraigned that morning in the county jail. But then when I left,
I
those are the only
you were
papers that they
arraigned,
gave.
you were arraigned on the 21st of December, not the 28th. And you were given
Yeah.
a piece of paper, which is your notice to appear. You were also told on the record of what your next court dates were, and you were assigned an attorney. Your attorney had not heard from you and was unable to make contact with you with the number you provided the court, and you failed to appear on both of those court dates. And so that was for preliminary examination and probable cause conference, because you're being charged with 3 felonies. Count 1, controlled substance delivery manufacturing, where you face a felony of 20 years and or $25,000. Count 2, controlled substance possession of methamphetamine, felony facing 10 years and or $15,000. Count 3, police officer fleeing 3rd degree under the penal code, felony 5 years and or $5,000. Habitual offender, 4th offense notice, and it lists the notices of why they enhance your charges, and that makes the maximum penalty life if primary offense has a penalty of 5 years or more, 15 years or less if primary penalty has a penalty of under 5 years. Your primary offense has a penalty of more than 5 years, so you are facing life because of count 1. And you didn't bother to come to court, even after posting a bond 5,010%.
Yeah, Your Honor, that morning when I got arraigned and they let me go, the only papers that I had on my property was my arraignment papers. I didn't know what my next court date was.
Your arraignment papers include, this is not new. We do arraignments every single day and on holidays such as today because the court is closed, and on weekends. And every time we do arraignments, we provide you, especially with a felony, you get your next court date in your hand from the jail the day you're arraigned. So if you lost those court dates in between you being arraigned and you leaving, that's your responsibility, because you were advised on the record what those next date would be, and you would have known that you are being charged with felonies, and at some point you need to go back to court, and you never came back to court. And here we are in February when you were supposed to be in court in December, okay?
Right, I'm sorry about that.
Well, sorry is not sufficient, because you are supposed to be more responsible than that. You need to get to court. We're not gonna be tracking you down or trying to find you to resolve your criminal matters. You're gonna need to come to court. Nonetheless, what's your home address?
3015 Newark Ave, Lansing, Michigan, 48911.
What's your phone number?
Phone number is 669-599-2350.
Two three
Sorry about
five
that.
zero.
Yes, ma'am. I know I
Okay,
should have called.
did you give a different number at your arraignment?
Yeah, but that phone number is no longer working, so I just have a text down number that I've been using.
Okay, counsel, you can address bond.
Thank you, Your Honor. I think now, if Mr. Yang didn't know before, he knows that he needs to keep track of his court dates and to appear and keep in touch with the court and his attorney. And hopefully he will do so moving forward. He does live here locally. It sounds like that he has family ties to the community. I know that he does have prior criminal history. From reviewing his prior criminal history, the majority of it, Your Honor, appears to be nonviolent property related or controlled substance related in nature. Given that, Your Honor, I would ask the court to consider granting Mr. Yang a reasonable bond that he would have a reasonable opportunity to post. Thank you.
Thank you.
I'm also,
It looks like,
business
excuse
too
me?
also. I said I'm also in the process of starting my own business right now too. Yeah,
Oh,
JC
okay.
Transportation.
Thank you for sharing. The court granted a reasonable bond back in December, 5,010% for a bond on a matter or matters that are facing a maximum penalty that could be up to life in prison. But none of those things seem to bring it to Mr. Yang's forethought that he probably should appear in court or make sure he knows where his court dates are, or maybe get in touch with his attorney so that he can start to help formulate a defense on crimes that could face up to a life in prison. And so the court does not believe that a release on bond would reasonably ensure the defendant's appearance for his next court date. And so bond is going to be, he's going to be remanded until the time of his preliminary examination. You're all set. On the record in the matter of the people of the state of Michigan versus Patrick Andrew Hayward.
Your Honor, we were asking that Mr. Hayward be seen last. He's still in his
Okay.
cell due to some.
No problem. On the record in the matter of the people of the state of Michigan versus Angelica Bethany Harrington. And this is for file number 24-00060 FY. Council appearance.
Good afternoon, Your Honor. Jared Austin appearing on behalf of Ms. Harrington. My appearance is limited to this hearing only.
Ms. Harrington?
Yes.
Okay, I had to read the police report. This is an allegation of a violation of conditional release, meaning the allegations are that you violated your bond conditions. Ms. Dawson, did I get your appearance correct?
Yes, I stated it on the record, Your Honor.
Okay, thank you. And so you were already placed on bond in the underlying matter. You were arraigned by Magistrate Milmore. One of those conditions included not to assault, harass, intimidate, beat, molest, wound, or threaten an Eric Harvey. There also was a bond condition that you were not to have or cause a third party to have any direct or indirect communication with Eric Harvey. The allegations of the police report that supports the bond violation alleges that on or about February 18, 2024 at 1:39 p.m. that you allegedly violated your bond conditions by both assaulting, harassing, intimidating, beating, molesting, or threatening Eric Harvey, and also that you had direct or indirect communication with Eric Harvey, and that these things would be in violation of your bond conditions. So you have the right to have a hearing on the bond violation, because if you're found to be in violation of your conditional release, your bond can be revoked and you can be remanded to the custody of the jail pending the underlying criminal case. Do you understand that?
Yes.
Okay. You also can be found in contempt of court for violating a bond order, because that's a court order. And so contempt of court is punishable with a maximum penalty of 93 days in jail and or $7,500 in fines. You understand the maximum penalty for contempt of court?
Yes.
Okay. She already has a public defender on the underlying matter, is that correct?
That is correct, Your Honor. It's Ms. Schroeder from our office.
The court will enter a plea of not guilty for the violations and have it set for a hearing on the bond violations, and that'll be set before the court that you're originally assigned to. You'll get that notification in the mail. What's your address?
824 Robbins Road, Lansing, Michigan, 48917. ROBINS.
1804.
824 ROBINS Road.
Okay, yeah, I see the paperwork had the address wrong, so we gotta get that corrected so that we can make sure that you get your notice to appear. What's your phone number?
517-525-6266.
Have you been in contact with your attorney?
Not yet.
Have you tried to call your attorney?
Not yet. I just turned my phone on, so I haven't had the chance.
Okay, you're gonna need to make sure you're in contact with your attorney, okay?
Okay.
Counsel, you can address bond.
Yes, thank you, Your Honor. Ms. Harrington was given a bond initially by the court. It looks like that bond was eventually reduced and she was able to post that. Prior to that, it sounds like her and Ms. Schroeder from our office was having discussions on Polycom. Looks like there is a final pretrial conference coming up on this matter in exactly 1 week. I can understand the troubling nature of this allegation, but I would ask the court to consider keeping Ms. Harrington released on bond, given that court date is upcoming in the next week. Thank you.
I'm also on tether.
That was going to be my next question. Yeah, you were ordered to be on a GPS tether. Are you still on tether?
Yes.
Okay. I'll continue your bond as it was originally set. As to the bond violation, I'll issue a bond of $500 on that condition. Actually, I don't even know if that's necessary because you're already on bond. I'm just going to continue the bond as originally set with GPS tether. Going to remind you of your no contact order. So you're not to have contact directly or indirectly with Mr. Harvey, who's the alleged victim in this matter. And so sometimes that could get confusing because there could be let's hypothesize that you're in a public place and he comes in contact with you. You have to do what's necessary to protect yourself if that's a situation. So you make sure if you are in a public place and he's there, you leave. Okay. If he's on the left side of the street, you want to be on the right side of the street. You want to make sure you stay as far away from his as possible so that you don't end up with a potential violation. Do you understand that?
Yes, what happens if he comes to my job?
Okay, if he comes to your place of work, obviously you're working, you can't leave. Your best bet is to call the police and let them know that you're trying to work and someone that you have a order that you're not to be within their reach is there and putting you in a precarious situation, and then let law enforcement come in and diffuse the situation. It's not for you to diffuse, okay?
All right.
Do you have any other questions about your bond conditions?
No, thank you.
Any additional matters for the record?
No, Your Honor, thank you.
You're all set, Ms. Harrington. Okay, let's see. On the record in the matter of the people of the city of Lansing versus Sir Trey Green, file number 24-00400, counsel appearance.
Good afternoon, Your
Yes,
Honor. Jared Austin appearing on behalf of Mr. Green for the purpose of this hearing only.
I had a search Trey Green on the record.
Thank you. Okay, Mr. Green, I have here a complaint of violation of conditional release. The allegations are that you violated the conditions of your bond.
Yes, ma'am.
Okay, they're alleging that your bond conditions, which were, let's see here. Not to engage in assaultive or threatening behavior against a alleged victim here, and to keep your CMH appointments were violated. This is with the allegations. It says you were allegedly within 20 feet of the protected person, staring him down and his girlfriend down. That's an allegation that was supported by a police report from February 19th, 2024 at 9:35 a.m.
Correct.
You have the right to, okay, you have the right to have a contested hearing on that violation. You have the right to be represented by an attorney at that hearing. If it is found that you did violate your bond can be revoked pending the underlying criminal matter. Do you understand that?
Yes, ma'am.
You also could be found in contempt of court for violating the court's order about your bond. Contempt of court is punishable with a maximum penalty of 93 days in jail and or $7,000. I'm sorry, $7,500 in fines. You understand that?
Yes, ma'am.
Okay, let's see. He has an attorney on the underlying matter, Mr. Austin.
Yes, Your Honor, he's represented by Ms. Sutter from our office.
What happened was, I was
Look,
in the.
don't speak about the facts, Mr. Green.
Yes, ma'am.
You have the right to, you got a right to remain silent. Anything you say can be used against you. We are on the record, okay?
Yes, ma'am.
You said he's being represented by Ms. Robinson, you said?
No, Your Honor, Miss Sutter from our office.
Ms. Sutter. The court will enter a plea of not guilty. This matter will be set for hearing. Do you know when his next court date is?
Yes, Your Honor, it looks like he has a pretrial hearing coming up on the 27th at 9:30.
You were aware of that already though, weren't you, sir?
Correct,
You were planning to be at your next court date, correct?
correct.
Okay, what's your home address?
It's, the City Rest Commission on Michigan.
Okay, so don't forget to appear at your next court date. We'll have this matter set for a hearing on the allegation that you violated your bond. I've reviewed the police report. I think based on the allegations, we can continue your bond at this time. I'm going to remind you of your bond conditions. You're not to have contact directly or indirectly with a Jacob Haraberta. You're also not to be within 2,000 feet of wherever they are. So let's say you're at Meyer and he walks into Meyer, you have to leave because you're not to be anywhere within 2,000 feet of where he is. Do you understand that?
Yes, ma'am.
Okay, and that may seem inconvenient, but during the pendency of this matter, it's for your protection as well as his, because you don't want any further allegations against you. You recognize that?
Correct.
Okay, so your bond has been set originally 500 personal recognizance with a no contact order. That will continue. Have you been appearing at all your CMH appointments?
The next one is the 28th.
Okay, so you got court the 27th, CMH the 28th, huh?
Yes, ma'am.
Okay, I'm glad to know that you are keeping up with your appointments. You're all set for today. Bond will continue.
Thank you.
You're welcome.
Thank you, Judge.
Do you have to switch to the iPad for the next one?
Yeah, we're gonna have to go switch to that. It'll just take us a second there.
Thank you.
Yes.
Okay, let's see.
Oh, and our video's not working. There we go. There we are. I don't know.
Very good. Mr. Hayward, can you hear me?
Yes, I can.
Very good. On the record in the matter of the people of the state of Michigan versus Patrick Andrew Hayward, file number 23-01973, council appearance.
Good afternoon, Your Honor. Jared Austin appearing on behalf of Mr. Hayward for the purpose of this hearing only.
Okay, Mr. Hayward. You have a case before me. Did you forget about it?
I can't even hear. I can't barely hear you.
Okay.
Can I hear you, Your Honor? I apologize.
Okay, you were supposed to be before me on the 16th of January. You didn't appear.
I
Where
did
were
not
you?
even know that. I did not,
Well, that's unfortunate. Because it's your responsibility to know when you have court.
I know, I apologize, Your Honor.
Yeah, I was sure that you would apologize. You were supposed to be before me on the 16th because you've got a list of requests and summons for probation violations. So you're on probation before me. Did you forget about that?
No, I did not, Your Honor. I cannot, okay, so, like, I don't know if I mentioned it to you, when I was in front of you guys. I'm disabled and I've been waiting for my disability and I haven't, it's like, I messed up some paperwork, so I had to start all over again. Like, it's been all bad. I haven't been able, I couldn't afford the drops. So like, I was like,
Okay.
you know, I apologize, Your Honor.
Okay, well, the allegation, sir, that you failed to pay fines and costs, no payments were ever made on your balance of $885. Let me speak. $885.14 that you owe in fines and costs and restitution. The allegations are that you failed to enroll in testing at EverHealth on October 2nd, 2023, and that you failed to provide proof of enrollment of any outpatient treatment. The allegations are that you failed to provide proof of employment or disability, and the allegations of non-technical probation violations are that you failed to report monthly for probation, and that you failed to report to probation October 19th, 2023, November 16th, 2023, and December 18th, 2023. It says defendant has absconded from probation. So you have the right to have a contested hearing. You have the right to be represented by an attorney at that hearing. If you are found to be in violation of your probation status, your probation can be revoked and you can be sentenced to a term of jail time. Do you understand that?
Yes, Your Honor.
Your probation could also be extended, or I can address your probation with additional sanctions or oversight or programming if necessary. Did you want to request an attorney to represent you?
Yes, Your Honor. Now, can I say something, Your Honor?
Let me just advise you of your right to remain silent again, because anything you say can be used against you. With you understanding that, you can say what you want to say.
So, like, when it, like, it's, I was under the impression, well, I was told by somebody that has done it before, for my fines and costs, is there any way that I can do volunteer work to pay for my fines and costs?
We don't need to worry about that right now, because we have more than just fines and costs at issue. You're not even reporting for your probation violations, okay?
I know, I apologize. I didn't report because
you're not even reporting for your monthly meetings with your probation officer. At least that's the allegation. So we don't need to worry about your fines and costs. On the tier of how I rank the importance of things, your payment of fines and costs fall at the bottom of the list, okay? That falls at the bottom of the list. So you don't need to worry about that right now. We got to address some other things first before we worry about your ability to even worry about or pay these fines and costs. Although I do believe there is some restitution. Nonetheless, did you meet with him prior to this, Mr. Austin?
I did, Your Honor.
Okay, you can address this bond.
Yes, Your Honor, thank you. I think as Mr. Hayward was alluding to. I think he's been struggling with a lot of things in terms of finances and other things. I think things just kind of spiraled and he got overwhelmed. Also, from speaking with him, Your Honor, it sounds like he has some really significant health issues going on right now. It sounds like he has a surgery scheduled within the next month or so. So he's really struggling in that area as well as financially and economically right now, Your Honor. So I would ask the court to take that into consideration and grant him a reasonable bond pending the violation hearing.
Okay, my biggest concern is the absconding and I don't want to have to go looking for you for your next court date. So the order actually was when the bench warrant was issued, I issued a remand bond because I'm not going to go looking for you to address this violation. So you'll be remanded until the time we can have a hearing on the violation and I can address your sentencing. Because if you can't properly participate in probation, then we can address your sentencing in other ways, such as jail time, okay?
Your Honor, please, I know I missed a court date in January, but I didn't miss a single court date before that.
Well,
I'm not
I
trying to
wouldn't go
run.
that far. I wouldn't go that far, because you like to come to court when you feel like it, because
No, I had to
January
walk.
7th,
I had to walk.
January 7th, you appeared whenever you felt like it. And then you did the same thing on January 14th. So both times I actually issued bench warrants for you, and then I quashed them when you later appeared. You did.
I know I had to walk from
Well, what I don't like is when I'm trying to talk and I can't get a clear record because you're talking over me. So that's fine. You probably need to talk to your attorney anyways. That's the order of the court. You're remanded until the time of the hearing on the bond violation. I'm sorry, on the violations of your probation. You're all set.
When is that gonna be?
That means that you're gonna stay in the custody of the jail until we can address this matter.
When is that gonna be?
We'll get you a notice once it's set. It's not set yet.
Thank you, Your Honor.
You're welcome.
Have a nice day.
Same to you. I think that's all I have today.
Okay.
Thank you, Mr. Austin.
Thank you, Judge. Have a good rest of the holiday.
You too.
You too.